We shall under no circumstances whatsoever be liable for any loss or damage to property of any member or guest brought onto our premises, whether occasioned by theft or otherwise, nor shall we be responsible in any way or liable for any personal injury or harm caused to the member or guest or their children or their guests on our premises. Okay, so exemption clauses, we've all come across them at some point in our lives. We've all been a party to the agreement. But what do they really mean? What does it mean for you and I? What happens, for instance, when you sign this agreement to send your little child on a grade 8 school orientation camp? You think your child is safe, you think they're going to have a great time, but then you get a horrific call. Your child has been found dead, drowned. He fell off a makeshift raft, was swept down the river and died. Obviously, when the dust settles, there's got to be a time where you look at the legal consequences. Is it of any consequence for the school or the camp to hold up the agreement that you signed and say, well, we're not liable for anything because you signed the agreement? Do we sign our lives away when we sign an exemption agreement? Find out here. How's it, everyone? Welcome back to Set in Arbiter. My name is Gil, and on this channel we talk about the law, how it is, why it is, and what it could be. Today we're talking about exemption clauses, and generally there's two things you're going to take away from today. The first being you're going to find out what exactly is an exemption clause, and secondly, what circumstances does it apply? In other words, what circumstances can we get around an exemption clause? So, what is an exemption clause? We see them everywhere, and I'm certain everyone's been a party to the agreement at some point in their lives. Either you're signing the agreement yourself, or your parents are signing it for you, or you're entering into a public space like a beach or a university, a theme park, the shopping mall, and they've got a sign or a notice board, or it's on the back of a ticket that has this exemption clause. In that way, when it's brought to your attention, then you are a party to the agreement, even though you didn't necessarily sign it, right? So we've all been a party to these exclusion clauses. But what they are is they're nothing more than a contract. They are an agreement. They're an agreement to exclude or limit or alter liability and remedies that would normally flow from civil cases. So in other words, what I'm saying is that you are agreeing to deviate from the normal remedies and normal procedures that would follow from most civil cases. In simpler terms than what I've just said, you've basically, in civil matters, you can't sue them under in cases where they fall under the protection of what you agreed to, and that's what an exemption clause really is. And they are standard form contracts. In other words, they're determined unilaterally, and there isn't really space to negotiate. You can't go into a shopping mall and say, well, I don't agree with this exemption clause, you must be liable if someone steals my car in the parking lot. There's no room to negotiate. You either agree to it or you just don't participate in the activity at all. So you must understand that in these contracts, you don't negotiate, you have a weak bargaining position. You either comply or you just don't take part, right? So your freedom of contract really only exists theoretically. Having said that, they do serve a legitimate commercial function. There's good reasons why we should have them in society. From the business perspective, it's a good spread of risk that's inherent in most transactions that they enter into. And also from a customer point of view, it actually ends up reducing the cost for us. If the business was liable for every single claim that came against them, they would have to recoup those losses from elsewhere, which means that it would be higher prices for their products and services, which means obviously higher prices for the end consumer. So there are good reasons why we should have the exclusion clause. Okay, now that we understand that exclusion clauses play a legitimate role in society, the question is, do you really sign your life away when you agree to these agreements? And the answer to that is no. There are a number of ways to get around them, and most things in law, the answer depends. But let's start off with the first thing, is that you can't exclude criminal liability. You can't contract out being a criminal. Okay, that criminal and civil cases are completely separate things. Okay, so you can't contract out being a criminal. That's pretty obvious. Then with civil cases, we need to discuss it a bit more. Generally, there's two ways that you can get around exclusion clauses in civil cases. The first being invalidity, and the second being an exercise of interpretation. So let's chat about invalidity. This basically means that the contract is invalid, and to invalidate a contract, you can normally rely on basic principles of contract, which hopefully I'll make a video about in the future. And there are several elements you need to meet, but the most problematic one for exclusion clauses is that there is a lack of agreement, right? Which means, it just basically means you haven't agreed to it. That's why there should be no contract if there's no agreement. So let's think of the first scenario where you sign an agreement. When you sign it, there's an idea of law that when you sign it, you have agreed to the terms. And that's pretty obvious, right? So it's proof that you have consented and you have agreed to these things. So it makes it more difficult to say that you didn't agree to something when you've got a signature there, obviously. So generally, if you do sign it, you're going to be bound to those terms. It becomes problematic when the terms have something that is surprising or that you wouldn't normally expect to find in those kind of agreements. So normally you can sign these things without necessarily reading them and understanding them. You know that if you sign them, you're going to exclude theft and personal injury and those kind of claims. But you don't necessarily agree that if you go, let's say you sign something to go, I don't know, shopping to a shopping mall, you don't expect there to be dogs there and you get attacked by the dog, and they say specifically in the exclusion agreement that we're not going to be liable for any attack by a dog, something specific like that. Then I know it's a dumb example, but the point is, if there's something specific and unusual that you wouldn't normally expect in these kind of agreements, then they've got to take reasonable steps to bring it to your attention so that you know that this is in there and it's not just a general exclusion clause. Okay, the second thing is when it's a form of a notice. And so where you're not signing it, where it forms part of a notice board when you walk into a place, a public place, and there's some notice board that says it there. That's also an agreement, but it wouldn't be an agreement if that notice board, if they haven't taken reasonable steps to bring it to your attention. So in other words, if you come onto the beach and there's an exclusion clause, but the exclusion clause is on the other side of the beach, 2 kilometers down the sand, nowhere near the parking lot where you came in, then they haven't taken reasonable steps to bring it to your attention. So things like it's got to be in a clear and obvious place. The writing has got to be in clear language, language you can understand, bold, things like that make it obvious that it's been brought to your attention. If not, there's certainly an argument that you didn't agree to those terms. Okay. So secondly, on invalidity is, after the lack of agreement, you have illegality, which means that the whole exemption clause is illegal, right? So the first main thing is on intention. You cannot have an exemption clause that excludes intentional misconduct. In other words, they can't say we protect ourselves if we intentionally steal your stuff, we intentionally hurt you, we intentionally cause harm to you. That no exemption clause is going to protect them from that, right? And this also extends to a specific type of intention. In law we call it dolus eventualis. Essentially it means if you subjectively foresee a real possibility that this certain harm will happen, and you do nothing and you are reckless in preventing that harm, it's said to be that you have this intention. This intention exists should that harm eventuate, right? It's not necessarily, as colloquially speaking, an intention that I intended to hurt someone, but it's an intention in that, a legal intention in that you foresaw that something bad could possibly happen in these circumstances. You knew this was a real possibility and you did nothing and you were reckless to that effect, and recklessness cannot be covered by an exemption clause. So for example, if we go back to the example we had at the beginning, if you knew that if you're going to put children on a fast-moving river with no life jackets, no adult supervision, there's a real possibility that the child might be swept away down the river and drown. And if you do nothing to that effect, you are reckless, and there is no exemption clause that's going to protect you. The second thing we need to talk about is negligence, right? Generally speaking, it's okay in law to contract out negligence. You can't claim if they say if we are liable for negligent things, it's perfectly okay for the business to say that they are not going to be liable for any negligent conduct. It becomes more problematic where it's gross negligence. In other words, where negligence is so bad. It's almost borderline going towards the reckless intention I spoke about, right? And this is an area of law. Gross negligence is an area that isn't settled in law. There is no definitive answer, right? There's been conflicting views, but I tend to think that if this came before a competent court, they would seem to look at it and say, well, we look at public policy reasons underlined with constitutional principles and values, and we think, particularly in cases where it results in death or serious bodily injury, then the exemption clauses for gross negligence is not going to protect them, it's not going to cover them, and it would be illegal, right? But as I said, this is not settled in law, and it remains to be seen. But I tend to think that you can't exclude gross negligence, only a mild form of negligence. Okay, so now we assume that the invalidity argument doesn't work. The contract is a valid contract, there's an agreement. The question is there a way to get around it through the second way, which is interpretation, right? And this one is also not settled in law. There is an exact way to go about interpreting these type of clauses. Sometimes the courts take a very formalistic approach to it. In other words, they say these are the words, this is what they mean, this is what they cover, and if you fall into if the business falls into that protection, then they are protected. End of story, end of matter, let's go home. And that, although that is one way of doing it, there seems to be a trend towards a more restrictive interpretation. In other words, we interpret it very narrowly. That it does, though, depend on how clear and unambiguous the words are. It depends on the facts of the particular case, and to some extent it also depends on the judge. But if they do decide to take a restrictive interpretation, what they do is they incorporate standards of fairness and reasonableness underlined with constitutional principles and impose that lens over the contract, and then they look at the words again through that constitutional lens in a lot of ways. And doing so, they can interpret it and saying, well, this clause is very unfair, it's unreasonable, that they shouldn't have some sort of claim in these circumstances, and therefore we're going to say that you're only protected in these particular circumstances, but the facts of the case are outside of those circumstances, and therefore they can bring a claim against you despite having the exemption clause. And in that way, restrictive interpretation can allow you to bring a claim, right? But like I said, it's not settled in law which way they're going to follow. A lot does depend on the facts of the case. How bad is the harm? How bad did you suffer? Did anyone die? Things like that those will make a material difference. And also, like I said, it depends on the judge. So basically, an interpretation exercise is possible, but it's not settled in law, and it would all depend, right? So that, guys, that is exclusion clauses. That's all you really need to know about them. Although they play a legitimate role in society, we do have to be careful about them, and there are ways to get around them. Businesses still have to take reasonable steps to prevent harm from being done, because there are ways to get around these exemption clauses. And in all, I think it's good for law that we can get around them, but it's also good for law that sometimes we shouldn't get around them. Okay, but yeah, that's all I have for you today, guys. Please remember to like, subscribe, comment, share, all that good stuff. And yeah, like I always tell you, remember that the law is only a tool, and like any good tool, its real usefulness depends on the person who knows how to use it and understands it. Remember, knowledge changes everything. Cheers for now, guys.